I knew I was being erased the moment I saw the CEO. Not my supervisor. Not a mid-level HR rep. It was the man himself, sitting at the head of the mahogany table like a king presiding over an execution. My name is Delaney Whitaker. I am 42. For 6 years, I've run the Raleigh Medical Device Facility, 43 employees, 3 shifts, 0 safety violations. I didn't just manage that floor, I built it into a fortress of predictability and profit. The CEO didn't offer coffee. He didn't offer a handshake. Restructuring. He said, sliding a silver folder toward me, "Your role is being eliminated, effective immediately." The package was standard, yet tempting. 12 weeks severance, full benefits through the quarter, a neutral reference. In my head, the math was instantaneous. 3 mortgage payments, my son's tuition, a bridge to my next role. I reached for my pen. Then I saw the rider. Section 14, non-disparagement. The employee shall make no statements, public or private, that reflect negatively upon the company, its leadership, or its proprietary manufacturing processes. No exceptions. The air in the room felt heavy. I didn't sign. Instead, I pulled a weathered folder from my briefcase, my original employment contract from 6 years ago. My contract includes Section 7.3, I said, placing the 2 documents side by side. The CEO's eyes narrowed. These are the new standard terms. Delaney, standard doesn't override a signed agreement, I countered. Section 7.3 protects my right to make truthful statements regarding workplace safety and regulatory compliance. I insisted on that clause. I won't trade my whistleblowing rights for a check. The HR director cleared her throat. You can decline the package, of course, but you'll leave with the statutory minimum. 2 weeks, I asked. 2 weeks, she confirmed. 2 weeks of pay against a $300,000 mortgage. For a split second, the pragmatist in me screamed to just sign it. Take the money, fade away. But if I signed that paper, the woman who fought for safety standards for 6 years would disappear. I need 24 hours. I said, "You have until noon tomorrow," the CEO replied, already looking at his watch. After that, the offer expires. Permanently. I spread the documents across my kitchen table like evidence at a crime scene. On the left, the life I had built. My 2020 contract. Section 7.3 was highlighted in yellow. Truthful statements. On the right, the cage they wanted to put me in. The new severance agreement. I remembered why 7.3 mattered. 2 years ago, a cooling unit on the main line failed. Corporate wanted me to adjust the logs. I refused. I told the COO that a recall would cost more than a repair. He hated me for being right. But he couldn't fire me for telling the truth. Now, they were using a restructuring to buy my silence retroactively. "Mom, you're staring again," my son said, leaning against the doorframe. "Just work stuff." "Leo, are you losing your job?" I looked at him. Then at the mortgage statement pinned to the fridge. $312,000 remaining? The company's changing. I'm just making sure I don't change with it. He didn't look convinced. "You look like you're bracing for a hit." He was right. At 11:45 p.m., a notification popped up on my phone, an automated system alert. "Your remote access to the Raleigh operations server will expire in 8 hours. They weren't just waiting for my signature. They were already cutting the cord. I opened my laptop. I didn't steal trade secrets. I didn't take client lists. Instead, I began BCCing my personal email every performance review, every safety audit I'd signed, and the email chain from the COO regarding the cooling unit incident. If they wanted to play hardball, I needed to make sure I had a bat. At 9:12 the next morning, my phone buzzed. Subject line, final reminder. I opened it. "Please be advised the severance offer will expire Friday at 12 noon. If not executed, executed." Like I was paperwork. Like this was routine. I called human resources before I could overthink it. "This deadline wasn't discussed yesterday." I said, "It's standard procedure," she replied. "Show me where it's documented." "It's part of company policy." When was it issued? 6 months ago. I never received notice. It applies to all departing employees. That's not what I asked. Pause. We expect your signed agreement by noon. She said, slower this time. I expect written documentation of this policy. I answered. Another pause. Longer. We're trying to resolve this efficiently. I'm trying to resolve it legally. She ended the call. I logged into the internal system. Employee Handbook. Last revision 2019. I searched my inbox for any update about severance terms. Nothing. No announcement. No required acknowledgement. No internal memo. If this policy existed, it hadn't existed when I signed my contract. I began saving everything. Original offer. Revised offer. Emails. Timestamps. I forwarded copies to my personal account. Downloaded headers. Screenshot the server time. It felt obsessive. It also felt like survival. At 11:45, Mark called. Delaney, are you going to sign? Does this clause override section 7.3? That's not my area. Then why are you comfortable asking me to trust it? He exhaled. You're making this harder than it needs to be. No, I said, I'm making it accurate. Silence. We need closure, he said finally. Closure. I drafted my response. Clean, direct. No emotion. I stared at the screen. When someone rushes your decision, what do you think they're afraid of? At 4:35, I reopened the draft. I read it again. Slower this time. I am willing to accept severance in accordance with Section 12.2 of my employment contract. That line felt steady. I cannot agree to additional terms that contradict Section 7.3. That line felt like a line in the sand. No anger, no accusations. Just the contract they signed. My phone rang. Human resources. Have you reached a decision, she asked. Yes, we need the signed agreement returned. You'll receive my response shortly. That wasn't what I meant. I know. Silence. You understand the offer expires at noon tomorrow? She said, I understand what my contract guarantees. You're risking 12 weeks of pay. I'm declining new terms. Not the severance already promised. That's not how we see it. It's how the document reads. Her voice cooled. We're trying to resolve this amicably. So am I. Another pause. You're making this adversarial. I'm making it accurate. She ended the call without goodbye. I attached the contract. Highlighted section 12.2. Highlighted section 7.3. Highlighted the non-disparagement clause. Side by side. No ambiguity. My cursor hovered over send. 12 weeks would cover 3 mortgage payments. Health insurance. My son's school fees. 2 weeks statutory pay would barely cover utilities and groceries. I almost rewrote the email. Softer tone. Less direct. Then I imagined explaining to my son why I signed away something I once insisted on. 4:47 p.m. I pressed send. The message left instantly. I stared at my inbox. No reply. No acknowledgement. No counteroffer. Just silence. The next morning, the betrayal was digital. I tapped my badge against the glass reader. Usually, it gave a cheerful green chirp. Today, it stayed a cold, stubborn red. I tried again. Red. The security guard. A man whose kids I'd sent Christmas cards to for 5 years. Wouldn't look me in the eye. He checked his monitor, his posture shifting into something defensive. It says, access suspended. Delaney. Suspended. On what grounds my transition period hasn't even been finalized. He gave me that tight, pitying smile people use when they're following orders they don't like. You'll need to contact HR. I have to ask for the badge. I handed it over. The plastic felt light, but losing it felt like losing an anchor. I was halfway to my car when my phone buzzed. A PDF attachment. Subject notice of immediate termination. I read it standing in the humid parking lot. Effective immediately. Your employment is terminated for cause. You will receive 2 weeks statutory notice pay. All other offers are rescinded. For cause. Those 2 words were a grenade. They meant no 12-week cushion, no benefits, no bridge. I hit the dial for HR before I even turned the ignition. I'm looking at a termination for cause. I said, Not bothering with a greeting? Explain the cause. You declined the signed transition agreement. The HR director replied. She sounded like she was reading from a script. Declining a new contract isn't cause for terminating an old one. I shot back. That's a breach of Section 12.2. You're trying to starve me into signing away my rights. The company has decided to move in a different direction. Your employment is concluded, and the 12 weeks guaranteed in my contract not applicable under a for cause separation. The line went dead. Not applicable. 6 years of exceeds expectations. 6 years of being the first one in and the last one out. I sat in my car, gripping the steering wheel until my knuckles went white. My phone rang again. It was Mark, my former peer in logistics. Delaney, I just saw the internal memo. He whispered, What memo? Mark, it says you were escorted out for policy violations. It's already on the private server. They weren't just firing me. They were poisoning the well. They were making sure that if I didn't sign their silence agreement, I'd be too toxic for anyone else to hire. This wasn't restructuring. It was an assassination. I looked at the corporate headquarters in the rearview mirror. They thought they had locked me out. They forgot that I was the one who helped write the security protocols. I didn't need a badge to remember where the bodies were buried. The courier envelope arrived Monday morning. It was heavy, professional, and arrived via overnight express. Legal departments don't spend $50 on shipping to send a thank you note. I opened it at the kitchen counter. My hands steady only because of the caffeine. Termination for cause insubordination and failure to comply with corporate policy. The air left my lungs. For cause was the kill shot. It didn't just take away my 12 weeks of severance. It took away my unemployment eligibility and marked my record with a black X. I dialed HR. My voice was a flat, controlled line. I'm looking at the letter. Define the insubordination. You refuse to execute the standard separation documentation. The HR director replied. I could hear her typing in the background. She was already over me. I didn't refuse to sign a separation agreement. I refused to waive my rights under Section 7.3 of my existing contract. There's a legal difference. That's your interpretation. Delaney, the company views a refusal to sign standard exit paperwork as a failure to follow a direct management order. Then the company is ignoring Section 14.1. I said, my eyes tracking the text of my original contract for cause termination requires 2 written warnings and a formal disciplinary hearing. Where is my file? When was the hearing held? A long pause. I heard the typing stop. The severity of the insubordination allowed for an expedited process. She said, her voice dropping an octave. Expedited doesn't mean non-existent. By whom was this authorized? I have nothing further to add. Please direct all future correspondence to our outside counsel. Click. The dial tone was the loudest sound in the house. I didn't move for a long time. Then I began the mapping. I cleared the kitchen table and laid every document out in a timeline. Left side, my 6-year history. Exceeds expectations reviews. Bonus letters, safety awards. Right side, the last 72 hours. The standard agreement. My email questioning Section 7.3. The lockout. The for cause letter. The gap between the two sides was a canyon of lies. They weren't just firing me, they were trying to gaslight the legal system into believing I had suddenly become a rogue employee after 290 days of perfect service. My phone buzzed. A text from a shift lead rumor is you got walked out for a safety violation. Tell me that's bull. My stomach turned. They weren't just protecting their money. They were destroying my name to ensure that if I ever spoke the truth, mentioned in Section 7.3, no one would believe a disgraced manager. I closed my laptop and didn't search for jobs. I searched for warriors, employment attorney, rally, retaliation specialist. I didn't just need a lawyer. I needed someone who liked the smell of a burning bridge as much as I was starting to. The attorney's office was smaller than I expected. No dramatic law firm energy, just a desk, 2 chairs, and a legal pad already open. Her name was Rebecca Sloan. She skimmed my contract first, then the severance agreement. Then the termination letters. How long were you employed? She asked. 6 years. Any disciplinary history? None. She tapped Section 7.3 with her pen. This clause protects your right to truthful statements about operations and safety. Yes, and they attempted to override that with a non-disparagement clause. Yes. She leaned back. That's called unilateral modification, meaning they can't rewrite a signed contract without your agreement. I didn't agree. I see that. She flipped to the termination for cause letter. They escalated when you refused. They're calling it insubordination. She nodded once. Refusing to waive a contractual right isn't insubordination. Then what is this retaliation? She said plainly. I exhaled slowly. Your contract also requires written warning and a disciplinary hearing before termination for cause. She continued. Did that happen? No. She closed the folder. You have a strong wrongful termination case. What does that actually mean? We can file a complaint with the North Carolina Department of Labor and prepare for potential civil action. At minimum, you're entitled to severance as written, possibly additional damages. How long? Months? Maybe longer. And cost. I work on a hybrid arrangement. Some upfront, some contingent. I nodded. I'm not doing this just for money. She held my gaze. Most clients say that. It's about the record. Exactly. She slid a representation agreement across the desk. If you want to proceed, sign here. I read every line. Then I signed. That afternoon, she filed the formal complaint. Is justice worth the time and emotional cost? Waiting is louder than conflict. I started interviewing the week after we filed the complaint. First facility. The hiring manager scanned my resume. So why did you leave your last role? Restructuring. I said, he studied me. Nothing performance related. No. Silence stretched. You understand we value stability, he added. I delivered it for 6 years. I replied. Second interview went smoother. What are you looking for? The director asked. A contract that means what it says. She raised an eyebrow. Fair. 2 weeks later, an offer came in. Higher base salary, signing bonus, health benefits effective immediately. I called Rebecca. I received an offer. I told her. That's good news. It doesn't change the case. I didn't think it would. It's not about the paycheck anymore. I know, she said. It's about the record. I accepted the job. My son hugged me that night. So we're okay. We're okay, I said. And this time I meant it. But I didn't withdraw the complaint. 3 weeks later, Rebecca called again. They've responded. Hearing scheduled in 8 weeks? Will they settle? Not yet. I hung up and stared at the calendar. The room was smaller than I expected. No audience, just a long table, the adjudicator at the front, and the 4 of us facing each other. The CEO sat across from me, same posture as the restructuring meeting. Calm, controlled. Corporate counsel beside him. A stack of binders open and tabbed. Rebecca leaned toward me. Answer directly. Don't volunteer anything. I nodded. The adjudicator began without ceremony. Miss Whitaker, your claim alleges breach of contract and wrongful termination. Is that correct? Yes, she turned to the company's counsel. You added a non-disparagement clause to the severance agreement. It is standard practice. He replied. She held up my employment contract. Show me where the contract permits unilateral modification of Section 7.3. He flipped pages. Slower than before. It is implied within company severance policy. She looked up. Point to the clause. Silence. He scanned again. Cleared his throat. It is understood I asked for the clause. None came. She shifted to the CEO. Was Ms. Whitaker offered severance consistent with Section 12.2 of her contract? She was offered a package. He said carefully, that's not my question. He hesitated. The package included updated terms, which contradict Section 7.3, she said. He didn't respond. She turned another page. Let's address termination for cause. Section 14.1 requires written warning and a disciplinary hearing. Did either occur? It wasn't necessary. The CEO said, was it conducted? No. Was there written documentation of insubordination? He looked at counsel. Counsel looked at his binder. No, he said quietly. The adjudicator leaned back. Standard practice does not override signed agreements. The room went still. Counsel attempted one last angle. The company must protect its reputation. By voiding contractual protections, she asked. No answer. I realized then they hadn't expected resistance. They'd expected compliance. Rebecca squeezed my arm under the table. Not celebratory. Just steady. The adjudicator closed the file. I will issue a written decision within 4 weeks. That was it. No dramatic ending, no declaration, just the weight of what had been exposed. As we stood, the CEO avoided my eyes. Outside, Rebecca exhaled. You did well. I just told the truth. I said. She gave a small nod. Sometimes that's enough. Decision pending. Do you believe the truth wins on its own or only when someone insists on it? Rebecca called on a Tuesday afternoon. It's in, she said, and you prevailed on all counts. I didn't speak right away. They found breach of contract. She continued. Wrongful termination. Procedural violations under Section 14.1. And the severance 12 weeks is guaranteed under Section 12.2. Plus 8 additional weeks of compensation for the improper termination. Legal fees covered. I sat down slowly. They have 14 days to comply, she added. Will they? I asked. They'd be unwise not to. 10 days later, the payment cleared, full amount, no deductions beyond standard withholdings, clean transfer, no apology attached, no explanation, just compliance. My son looked over my shoulder at the screen. So you won? He asked. I was right. I said, that's better. Yes, at my new job. No one mentioned the case. I didn't bring it up. I didn't post anything online. I didn't send a single email to anyone at the old company. 6 months later, I heard through a former colleague that the CEO had moved on. Voluntarily, I asked, that's the word. I didn't press further. The decision was public record. Anyone who wanted to know could read it. Every finding, every clause. One evening, I opened the folder again. Section 7.3. The language hadn't changed. It didn't need to. Truthful public statements regarding workplace safety and operational conditions. That clause protected me because I insisted it be there years ago. That's the lesson. If there is one. Negotiate like you're going to need it later. Read what you sign. And when you draw a line, understand the cost. If you ever face something like this, don't panic first. Read first. I closed the folder. She never had to speak publicly. The contract spoke for her. If you knew you were right, would you have the patience to let the record tell your story?